Good morning, everyone. Good evening for those down under, and good afternoon for everyone else. Actually, good afternoon to me, because it's just gone midday here in the UK. So we're here to talk about the Delphi case. So it's been a minute since I covered the Delphi case. There hasn't been much happening. There was a court filing by Slick Nick, which I didn't respond to, because it just annoyed me. But this one came out yesterday, and it's very interesting. It's pretty explosive, actually. It's my title's not hyperbole. This is going to really anger Judge Gull. When she reads this, she's going to be angry. She's going to be fuming. So for that reason, I like it. So we're going to go through it. It is 21 pages. So we're going to be a minute doing this. There is also a new interview, I believe, with Patrick Westphal, you know, the chief ordinist. I haven't watched it yet, but I thought what we could do is watch it together. So, like, I haven't seen it. Some of you might have seen it, but you'll be getting my raw reaction to it. So I might do that tomorrow. I think I'll do that tomorrow, unless there's anything kind of breaking in any of the other cases that I'm following. And there's also Riley Strain's autopsy has come out, like the full autopsy report. So I'm going to do a video on that. I'll do that on Michelle Walks. So that's either going to be today or tomorrow. I'll go through the autopsy report, because I do have a playlist about autopsies. So I like reading autopsy reports. It's not a long one. It's not particularly, what's the word, surprising at all. There's nothing controversial about it. So it's only going to be quite a short video. But I'll do that either today or tomorrow. It'll probably be tomorrow. I'm not sure yet. And then at 6 p.m. my time tonight, that'll be 1 p.m. Eastern, we're going to do episode 4 of the Stearns Files. So we're starting with an interview with Maddie's friend, Madeline Soto's best friend, and we'll see how far we get after that. So I'll put the scheduler up later, and that'll tell you what time that is in your local time. So 6 p.m. my time, UK time, 1 p.m. Eastern. So that's going to be what, 10 o'clock Pacific? And whatever it is in your local time, the scheduler will tell you. All right, let's say a few hellos. Oh, we got some gifted memberships as well. Let's have a look here. Purple AJ gifted 5 memberships. Thank you so much. What a superstar. Unbelievable. All right, Black Swan, Tinkerboo, Natalie. I cannot pronounce your name, but it begins with an U-O-E. Strange letters. I don't know. I don't know how to say your name, but you've also got a member, and dang it. So thank you, Purple AJ, and you 5 people, lucky people, get a month's free membership courtesy of the wonderful Purple AJ. And if you want a gifted membership, like it's a lottery, you know, when people donate memberships, gift memberships, it goes to anybody. YouTube decides it. It's not anybody. It's not me that decides it. It's not the person gifting the membership that decides it. It's YouTube that decides it. But you have to have your membership gifting turned on. So if you go down to where you do your chat, the chat box, and click on the $sign, which is where you do super chats and stuff. If you go into that and go into memberships, then it will direct you how to turn on your gifted memberships. I think that's how it works. So you have to have membership gifting turned on for this channel to be eligible to get a gifted membership. All right, so let's say a few hellos. RZ TV, hello. Linda, hello. Mrs. Sparkles, Angie Baby, Naomi Rose, Sassy Britches, Holly. Thumbnail reminds you of the song. Yeah. The song's not Why You Always Lying, yeah. Holly, Pincho, the judge is going to trial next. Oh, that would be nice, wouldn't it? Hello, hello. Look. I know we're on completely opposite sides here. I think we agree on a lot, Mr. Tomato Head, but I think with this case, we don't. Not that I think Richard Allen is innocent. Let's be clear. I don't know. I don't know. I think there's think the PCA has got some merit, but it's relatively weak compared to others. And there's a lot of doubt, a lot of reasonable doubt that the defence has brought up. But whether Richard Allen is factually innocent, I don't know. The reason why I support the defence in this case is because of the way that Richard Allen has been treated, the way that the defence team has been treated. It's not right. It's not constitutional, surely. So that's why it sounds like I'm pro Richard Allen. But anyway, judge didn't say ignore the subpoena. Prison didn't say that either. The prisoner ignored the subpoena. The defence twist things and y'all eat it up. Listen, what would happen if you or I ignored a court subpoena? What would happen? If we'd been subpoenaed to appear as a witness in a court, doesn't matter whether it's my country or your country, the rules would be the same. What would happen? You've just ignored it. You'd be found in contempt. And there's a sanction to that. There's a sanction to that. Now, as someone who is already incarcerated, they can't ignore a subpoena. It's up to those in charge of that inmate to make sure that they don't break the law. So no, it's not twisting it. It's the fact that somebody allowed an inmate to commit an offence. That's a problem. That's a big problem. Hello, CW, two Arctic Wolves. What else have we got in here? Black Swan, Purple AJ, we've already said hello. Karen, another Karen, different Karen. Bayou Baby. Going down here. Pix Plays, Ali, Sirius Black, M Thunder, Mama Shell, Jay, Ben, Kimberly, Della, Sharina, Osland, Bonnie, Paper Chaser, Kathy, Queen of Ravens. Got a bunch of people in now. All right. Going to start with the roll call and we're going to get straight into this one now. So it's 21 pages and this is the defence responding to Judge Francis Gull. So a while back, the defence put together a motion asking Francis to recuse herself. It's the second time that they've done that. The first time she just ignored it. She just said, denied without hearing. So this time they said, listen, you've got to respond with some actual law, some actual law to prove why you shouldn't recuse yourself. So she responded, ignoring that, saying, oh, well, trial rule, no, means I don't have to respond like that. So, but she gave them a whole bunch of home truths in response. So this is the defence's response to Judge Francis Gull's response. All right. So that's the context. So accused response to this court's May 31st order of judgment of the court and notice of conflict. Comes now the accused Richard Allen, by and through counsel, files his response to this court's May 31st, 2024 order or judgment of the court and notice of conflict. In support of said motion, Mr. Allen states the following. On May 31st, this court issued its order or judgment of the court concerning the defence's request to have Judge Gull disqualified, or recusing herself, same thing, I guess. Contained in said order were several errors. If the defence is filing this motion to preserve those errors for future courts, if needed. Now, everything that the defence is filing, I mean, literally everything that the defence is filing, is to create a record. Brad Rosie's very good at that. You know, the time when she called them into her chambers where she was going to name them and shame them, the only time she's allowed cameras in, I believe that was the 19th of October. Brad Rosie played a blinder, absolute blinder, because he set a record. You know, he didn't go to pieces. He didn't argue. He was very, very calm. And that record of what happened, everything he said was very, very clear. So Brad's good at that. I think Andy's a little bit more emotional in his responses. But Brad is very, very reasoned, very logical. And, you know, Brad knows, they all know that you know, if Richard Allen is convicted in October, if indeed it goes to trial in October, they're going to have a record of everything that has happened in this case, like pre-trial, and you know, they're working off the premise that that trial, once it actually gets going, isn't going to be a fair trial. Given the way that the judges responded to Brad and Andy, you know, having them disqualified for no reason, that's proof enough, if you needed any proof, to, you know, to say she's not a fair judge. So if Richard Allen does get convicted in an unfair trial, then they've got grounds for appeal. So they're making a record for the future. Right. And to notify the court that due to new information learned in her order, a conflict has been revealed which has caused Judge Gull to become a witness. She's going to be furious. I'm going to hear the explosion from here, from my little back bedroom where I do these live streams. I'm going to hear the explosion when Judge Gull reads this filing. Her head's going to blow off. The defence files this response and notice for purposes of maintaining a record, does not wish for this pleading to delay future hearings. So again, this is for future record. And I think that the way that this is worded itself sends Judge Gull a message that listen, lady, we are compiling a record for the future. That should give her pause, but of course it won't. All right. So they don't want this pleading to delay future hearings. They don't want to delay the trial anymore, but they're making this record. Particularly hearings related to the defence's request to transfer Richard Allen out of the Department of Corrections, which is the most urgent of the pending matters that needs litigating. So she's got a bunch of stuff that she still hasn't responded to, as always. But what are you doing, Cassie? Oh, it's okay. It's okay. Yeah, so they've requested Richard Allen be moved from Wabash back to a county jail. They've been wanting that for forever, but we'll see. Also, the defence's response is intended to provide correct information to Judge Gull as she continues to self-evaluate her obligation to recuse herself from the case, should she believe that bias or the appearance of bias exists. Well, she doesn't see it as bias. She is biased. If she had any form of, you know, self-enlightenment at all, she'd know that she was biased. So a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Okay. So, first issue. Judge Gull failed to inform the defence that Carroll County Sheriff's Office fabricated facts in a report filed in her court. So either Carroll County fabricated facts or she did. Which is it? In his motion to disqualify, Mr. Allen noted that, according to a June 14th, 2023 report filed by the Carroll County Sheriff's Office, hereinafter CCSO, Judge Gull advised Carroll County that it could ignore a valid defence subpoena for Westville Correctional Facility inmate Robert Baston and refused to transport him to the June 15th, 2023 hearing on Mr. Allen's emergency motion to modify safekeeping order. So modify the safekeeping order that Judge Dean assigned before he then immediately after recused himself from the entire case. And that's how Judge Gull got involved. So modify that safekeeping order to allow Richard Allen to be housed in a county jail. The safekeeping order supposedly to keep Richard Allen safe in the Department of Corrections. Well, he was terribly treated in Westville. I don't think he's being as badly treated in Wabash. I think there are issues with Wabash that Scremin and Labrato, the interim attorneys, noted. I think there are issues with Wabash, but I don't think he's being mistreated. He seems to have put on some weight. So whatever was going on at Westville was terrible. And we know he was being looked after by Ordinist guards. One so strong in his beliefs that when he was told he wasn't allowed to wear Odin patches to work anymore, he had a face tattoo. I mean, come on. These were the people who were looking after, I say that in the term as loosely as possible, Richard Allen in Westville. So presumably there's no Ordinists in Wabash. However, they still want him moved to a county jail because then they'll be able to, he's a lot closer. They have a room where he will be, they can go and visit him for, necessary trial prep and things like that. His wife and family will be able to visit him more easily than in the Department of Corrections, where apparently they don't even have a room where attorneys can meet their clients, which is bizarre. Anyhow, the defence further alleged in its motion to disqualify that because Judge Gull's actions, the defence was without a key witness for the hearing. So if you remember way back when, to June 14th, the transport arrived to Westville to pick Robert Baston up ahead of his appearance as a witness at the June 15th hearing. And Robert Baston refused to come out of his cell. And it goes into it in a minute, but in short, it appeared that it was Judge Gull, or at least Judge Gull's office, that told them that they didn't need to bother bringing him. That's what we were led to believe. But she said something different in her response, her May 31st response. She said something different. So which is it? All right. It was anticipated that at the June 15th, 2023 hearing, Mr. Baston would testify as to the harsh, abusive and unconstitutional treatment of Richard Allen at Westville. The failure of Carroll County to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, hereby subverting justice for him. However, in a May 31st, 2024 order, Judge Gull claimed that she never advised Carroll County to ignore the subpoena and leave Baston behind. Judge Gull's claim contradicts Carroll County that this court received on June 20th of 2023. The June 14th, 2023 report, which was ordered by the court, stated the following. And this is what Deputy Wizocki wrote after the fact. So he was the guy who was transport. So he wrote, when Baston refused to, honour the subpoena and wouldn't come out of his cell, then Wizocki had an issue. And this is his report post that problem. So on June 14th, 2023, I, Special Deputy Wizocki Brian, while on duty, was conducting transport from Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to Baston, Robert, segregation unit to conduct this pickup. After waiting, a corrections officer approached and told me Baston is refusing to come out of his cell and told the corrections officer, "Fuck you, You can't make me go. The corrections officer told me that they will do a cell extraction to get him to my transport vehicle. I told the corrections officers to stand by, let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gallipo, who's the warden, like the governor, like the head honcho of Westville. I called Carroll County Jail Commander Laurie Sustasik, who I explained the situation to. She then made a phone call to Chief Deputy Tobe Leesenby, who contacted Judge Francis Gull's office to inform them of the situation. Judge Gull's office advised to leave Baston there if he didn't want to attend the court hearing that is scheduled for 6/15/23. I then spoke with Warden Gallipo and asked if he could provide me with a letter stating that Baston refused to come out of his cell and that he did not want to go. Warden Gallipo agreed he would. He later advised he would bring me the letter on 6/15 to Carroll County Courthouse so I could attach it to this report. Nothing further at this time. So Deputy Wysocki, covered his bases. It's not his fault, right? He was following orders, which apparently came from the judge's office. So I can see what Francis Gull might try here and say, oh, well, it was someone from my office. It wasn't me. It wasn't me. It was just someone from my office, because she's thrown her staff under the bus before. So why wouldn't she do it now? I don't know. So somebody's lying. Somebody is not telling the truth here. Someone is fabricating facts. Whether it's Judge Gull via her office or whether it's Tobe Leesenby, somebody's lying. The report was approved by Tobe Leesenby, who is a key witness in this case. Juxtaposed to the Carroll County Sheriff's Office report is Judge Gull's May 31st, 2024 order, in which she states the decision by the deputy to leave without the witness was his and not directed by the court. So she's either trying to throw Wysocki under the bus, that Wysocki made his own decision, turns up to transport. Baston says, fuck you to the corrections officer. The corrections officer says he's not going to come out of his cell. What do you want us to do? And Wysocki said, oh, just leave him there. That didn't happen. Wysocki covered all his bases there. So phone calls were made. So is it Tobe Leesenby that's lying? Did Tobe Leesenby pretend to ring Judge Gull's office but didn't, and himself made the decision to say, oh, just leave him there? Because Leesenby himself is a witness for the prosecution in this case. So is Leesenby lying that he contacted the judge's office but didn't? Or is the judge lying? Which is it? The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. Now, I went through that response by Judge Gull and I said, she's lying. Someone's lying. Made the point. So it's the first we'd heard of it, this contradiction. Judge Gull has possessed this report since June 20th, 2023. Upon receiving this report nearly a year ago, Judge Gull never notified Mr. Allen's attorney of the misrepresentation contained in the report as it related to her purported involvement in the failure to transport Mr. Baston to the hearing. And again, yes, it's Robert Baston who said, I'm not going, but Robert Baston's an inmate. So Robert Baston basically has no choice. He can kick and scream and do whatever. But if he's legally obliged to turn up to court as a witness under subpoena, it's his jailers, it's Westville, who have the responsibility to ensure that he doesn't commit a crime. So they wanted to do a cell extraction to get him into the transport vehicle. So they can't be blamed because they said, well, extract him from his cell. And then phone calls are made, and no, Baston got his own way. So a legally issued court subpoena, which on refusal put Baston in contempt of court, but Baston isn't his own man. Baston is an inmate. Therefore, it's up to the people responsible for Baston to make the decision. So who is it that's in contempt of a court subpoena? It's either Judge Gull's office, who are in contempt, or it's Tob Leesenby, who is in contempt. Which is it? Could I please do a live about Jay Slater currently missing in Tenerife? I can do. Is he still missing? He's the lad from Oswald Twistle. Am I on the right guy there? Oswald Twistle, Lancashire. I think I am. Yeah, I'll do something for him. Okay, at this very moment of learning that Carroll County filed a report with fabricated facts concerning Judge Gull, she should have immediately alerted Mr. Allen's attorneys to the misrepresentation contained in the report. So, if when Judge Gull got Wizoki's report on June 20th, and clearly she carefully reviews everything that she gets in, and she thought, hold on a minute, my office didn't tell that. My office didn't say that. Hold on a minute. I didn't say that. I'm sure my staff wouldn't have said that. So she should have been on the phone to Tob Leesenby to work out what was actually going on. But no. So once again, is she lying? Thank you. Who's this? A to Z, thank you so much for gifting 10 memberships. That's very kind of you. Very, very kind. So we've got Bridget, Lisa, Sharina, Donna, Holly, Akira, Scout, Mama Shellbell, It's Just Me, and Mythical. So you 10 lucky people get a month's free membership of this channel. Go and check out the cute puppy pics and stuff, and videos and live streams in the members area. And thank you, A to Z. That's very kind, very generous of you. All right. Further, upon Judge Gull learning of the misrepresentation contained in the report, which undermined the evidence Mr. Allen was able to present, Judge Gull never reset the hearing so Mr. Allen could present the very evidence Judge Gull said was lacking when she denied Mr. Allen's emergency motion to vacate the safekeeping order. Additionally, as this court is aware, Mr. Allen has filed 4 Franks motions indicating that law enforcement has acted intentionally or in bad faith. So if this is Tob Leesenby's issue, if Tob Leesenby lied, saying he contacted the judge's office and didn't, well, that's another act of law enforcement that's bad faith, because Tob himself is a witness in this case for the prosecution. So he shouldn't be anywhere near this. None of the law enforcement who are going to be witnesses in this case should have anything to do with things like, making decisions about transporting inmates who are under court subpoena. And if they have to be, then they should act in good faith. So is Tob Leesenby the man whose head's on the chopping block? Or is it actually the judge? Jazz, thank you for the $5. Thank you so much. Very kind of you. Thank you. Is the seagull a custom emoji for this ongoing case, or from when Michelle got attacked by seagulls? I've never been attacked by seagulls. But yeah, it's in reference to this case, as is the wheat emoji. If you remember the the Supreme Court hearing, where wheat, it was every other word, it was wheat. So we've got a wheat emoji for that as well. Lisa, thank you for the $20. Go Steelers. Thank you so much. That's very kind of you. Thank you. Thank you. I've never been attacked by seagulls. Yeah, there you go. Sandra's got the wheat emoji. There's a bunch of emojis. There's going to be some more emojis coming soon. All right. Also, as this court is aware, Mr. Allen filed 2 separate motions to dismiss based upon law enforcement's destruction of evidence. One of those motions was heard on March 18, 2024, with the court denying said motion on April the 2nd. To prevail on a motion to dismiss, as it relates to the destruction of potentially useful evidence, the motion to dismiss requires the defence to prove that law enforcement acted in bad faith. At the March 18, 2024 hearing, defence counsel was attempting to provide evidence to the court the law enforcement had acted in bad faith over the course of this case. At this time, this court was aware that law enforcement had fabricated facts contained in the June 14, 2023 report, therefore acting in bad faith. Yet this court never alerted the defence, and therefore law enforcement bad faith was not part of the record. Even if this court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the fact that the defence was not able to include that information on the record for the Court of Appeals should it be necessary. Additionally, had Judge Gull alerted Mr. Allen's attorney of Carroll County Sheriff's fabricated statement in that report, so the June 20th report, the defence could have used that fabricated statement when pursuing their Franks motions and motions to dismiss in order to provide additional evidence of intentionality and bad faith on part of Carroll County. I can see a Franks 5 in the near future. I can see there's going to be Franks 5. Furthermore, by failing to provide this information to Mr. Allen's attorneys, Judge Gull prevented the defence from investigating this fabricated story, included through depositions. Judge Gull should have alerted Mr. Allen's attorneys of Carroll County's fabricated facts written in their police report well before the March 18, 2024 motion to dismiss, and her failure to do so provided a rational inference of bias. All right. Second point. Judge Gull is now a witness in this matter as to Tobe Leesenby's credibility. Given that Judge Gull is the only individual who knows that she did not direct the Carroll County office to ignore the subpoena and leave Mr. Baston at Westville, despite the contrary assertions in the Carroll County report, she has become a witness to Tobe Leesenby's truthfulness and to the fact that the information contained in Carroll County's report is false. I'm going to bet that Carroll County's report isn't false and that it's her office that is at fault. I'm going to bet that. I don't know. I'm just going to bet that. The credibility of a witness is always an issue for the jury. If Judge Gull's story is correct, then she has a ringside seat to the intentional behaviour of the Carroll County Sheriff's Office and or the bad faith of the Carroll County Sheriff's Office in that it, 1, intentionally ignored a valid defence subpoena for a defence witness, and then 2, fabricated a story in a police report claiming that the sitting judge on the case authorised the Carroll County Sheriff's Office to ignore the valid defence subpoena. In this scenario, Judge Gull is a witness. So they've got her over a barrel here. She's either got to admit that it was her office that told Tobe Leesenby to tell the transport staff to leave Mr. Baston where he was. It's either got to admit that it was her, or she literally has got to throw Tobe Leesenby under the bus. Which is she going to do? I think she's going to blame one of her staff and say, it's nothing to do with me, it's my staff, and that staff member, she'll probably say, oh, that staff member no longer works here, or something stupid. She'll get out of it, but the point of this is to create a record for the future. You've been crapped on by a seagull. Fun fact, when I was little, like tiny. I was scared of birds because I thought they had no eyes. I mean, seriously, I thought they had no eyes in it. I was terrified of birds. And I remember being on Blackpool Beach one time when I was little, and there was just loads and loads of seagulls everywhere. And they're very leery, like they come right up to you, like to get food. And I was terrified. I was screaming. They had to take me off the beach because I was screaming that much because of all these seagulls. I'm not scared of birds anymore. However, they're not my favourite things. They're not my favourite thing. I don't trust them. They're too clever. I don't trust them. All right. In future hearings and at trial, the defence should have the ability to cross-examine Tobe Leesenby on these contradictory stories with questions similar to the following. So these are suggested questions that they might ask Tobe Leesenby. Mr. Leesenby, the defence attempted to bring a witness named Robert Baston to testify at a hearing concerning his observation of guards abusing Richard Allen in a variety of ways at Westville. But your office ignored a valid subpoena to bring that witness to a hearing. Isn't that right? Leesenby, you did not want the judge to hear the testimony of that witness because it would support the defence's contention that Richard Allen was being abused and should be moved to the Cass County Jail closer to both his family and attorneys and away from the abuse. You wanted Richard Allen to remain in the Westville prison so that he could continue to be housed far from his attorneys and family while emotionally vulnerable to the abuse he was suffering at Westville. Worse yet, you then lied in a report claiming that Judge Gull advised you that it was okay to leave Baston behind. You lied about that in your report. Judge Gull never told you that it was okay to ignore a valid defence subpoena, did she? I'm handing you Exhibit 85, which is the June 14th, 2023 report from Carroll County Sheriff's Office. I think that should be all. In which you claim that Judge Gull gave the directive allowing you to ignore the subpoena, etc., etc., etc. Because the defence is claiming that law enforcement had acted in bad faith, and bad faith is an important component to its motion to dismiss, as well as the 4 Franks motions, it should be able to call Judge Gull to the stand to testify concerning the false statements contained in Carroll County Sheriff's Office June 14th report. Judge Gull's testimony is especially vital concerning the defence motion to modify the safekeeping order, as well as their Franks motions and motions to dismiss. Calling Judge Gull to the stand to testify as to fabricated facts contained in this report is especially important when the very witness who is the subject of this report, Robert Baston, would have testified about Richard Allen's treatment at Westville, which directly led to the deterioration of his mental state and false statements concerning his involvement in the crime. The defence plans on issuing subpoenas and calling Judge Gull to the stand at future hearings and at trial to testify that she never directed Carroll County Sheriff's Office to ignore a valid subpoena, and also never advised Carroll County Sheriff's Office to leave Robert Baston behind if he did not want to attend the June 15th hearing. Oh, she's going to be furious. Judge Gull should recuse herself from this matter as she is now a witness in the proceedings. She can't be a judge and a witness. So she's totally over a barrel now. She's totally over a barrel. She's definitely in check. If this was a game of chess, she's definitely in check. She has to wriggle out of this now. She either has to admit that it was her office, or she has to throw Tobe Leesenby under the bus. And if she throws Tobe Leesenby under the bus, then she is a witness. And she can't be a judge. She is a witness. All right. Judge Gull's failure to admonish the Carroll County Sheriff's Office may cause law enforcement to believe that they can create fabricated stories in this case with no consequences. Well, it seems that they do everything else without any consequences. We'll come on to that when we get to Slick Nick. Despite having the Carroll County Sheriff's Office report since June 20th, to this day, Judge Gull has failed to admonish the Carroll County Sheriff's Office for filing a report that contains such a flagrant falsehood, in which is argued an attempt to cover up their illegal actions by ignoring a valid defence subpoena. Yes, it's them that has committed the offence. It's them that's in contempt of court because Robert Basson is an inmate. It's them. Whoever actioned not honouring that subpoena is the person who is in contempt of court. So is that Judge Gull? Is she in contempt of her own court? Judge Gull's failure to address that fabrication in any fashion whatsoever provides a basis for state's witnesses to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence. This provides a rational inference of bias. Next point. Judge Gull continues to errantly accuse the defence of improperly filing ex parte documents. All right, so this is moving on to the fact that Slick Nick appears not to know what ex parte means. So ex parte means for one party only. So if a court a motion or a piece of documentation says ex parte on it, it basically means for the judge's eyes only, not for the other side's eyes. So Slick Nick shot himself in the foot, and it showed very clearly that he'd been reading the defence's ex parte filings that he should have absolutely zero knowledge of, because ex parte is for only the judge, not for the other side, by including some of the information from one ex parte motion in a motion of his own, which he ended up having to delete and rewrite. So all that went down. Now, Judge Gull doesn't appear to have, disciplined Nick for reading ex parte filings. Why not? Why not? All right. In its May 31st, 2024 order, this court continued to claim that the defence is to blame for ex parte pleadings that were accessible to the prosecution. Okay, so this is the story. On March 7th, 2024, Attorney Rosie alerted Judge Gull about his grave concerns surrounding McClelland receiving ex parte documents. It took Judge Gull 13 days to respond to this urgent matter. I mean, that's quick for her. You have to admit, most of the time she just ignores things. So 13 days, actually quick for her. But anyway, in her March 20th, 2024 emailed response, Judge Gull wrote to the defence counsel, she hates it. She hates it when they quote her emails. She hates it when they quote her emails in filings. So she's going to hate this. I would encourage you to educate your staff on how to properly file pleadings. That was her response. When Rosie alerted her to the fact that McClelland was reading ex parte filings, she said, it's your staff. Your staff's at fault. They should educate themselves on how to do things properly. That was her response. Not admonishing Nick McClelland for reading ex parte filings. I mean, Nick himself, if he'd got an ex parte filing in his inbox, he shouldn't have read it. He should have alerted the court to the fact that he'd received this ex parte filing that isn't for his eyes. He should have been the one to say, hold on a minute, I shouldn't get this, sort it out. He should have been the one to alert Judge Gull to the fact that the defence were perhaps filing ex parte motions incorrectly. Turns out they weren't. So how did Nick McClelland get his hands on ex parte motions? None of that has been investigated. Okay. Attached is a printout from the DocsPop filing process of the February 26, 2024 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. Okay. So they're blaming the court staff for when they file an ex parte motion, then the court staff needs to, on their end, click the relevant buttons so that Nick McClelland doesn't get sight of them and that it's for judges' eyes only. So the defence can't do that. The court staff have to do that. It should be noted, upon receiving this February 26, 2024 pleading, court staff would see in bold font and capital letters at the top of the pleading the following: ex parte pleading to be placed under seal, which should have easily alerted court staff of the ex parte nature of the document, causing them to follow the proper procedures in processing an ex parte pleading. But if the court staff made a mistake, which perhaps they did, Nick McClelland received this document that he shouldn't be reading. He should have said to the court, I shouldn't have received this, something's gone wrong. But he didn't. He kept quiet, but then shot himself in the foot by including information from an ex parte filing in his own motion. The staff for the defence filed the ex parte document correctly. The DocSpot printout shows that the only service contacts listed on this ex parte filing were Brad Rosie and Andrew Baldwin, not Nicholas McClelland, James Luttrell, or Stacey Diener. Furthermore, the printout shows that all documents were marked as confidential. I've got a footnote here. In a May 31st order, Judge Gull seems to believe that parties can only file ex parte documents through the Odyssey system. If so, she's incorrect. Parties may also file ex parte documents through the DocSpot platform, which is the platform defence staff utilise when they correctly filed the February 26 ex parte document in the case. Over the course of this case, defence staff has used both Odyssey and DocSpot platforms when e-filing ex parte documents. It is telling that the tutorial Judge Gull sent to the defence, she sent them a tutorial. She sent them a tutorial on how to do it correctly, but they were doing it correctly all along. So it's telling that the tutorial Judge Gull sent to the defence details how court staff should process ex parte documents they receive in the Odyssey platform, not the DocSpot platform. Okay, there is nothing else further that the defence can do to prevent these documents from being made public or misdirected to the prosecution. After the defence correctly files the ex parte document, the defence must then trust that the court staff has been properly trained on how to navigate an ex parte filing, whether it's filed using Odyssey or DocSpot. So she's going to blame her staff. Or she's going to say, well, my staff did it correctly. And if her staff did it correctly, and she can prove that her staff did it correctly, well, how did Nick McClelland get his hands on an ex parte filing? How did that happen? Is someone in the court leaking ex parte filings that have been correctly filed to Nick McClelland? Which is it? Okay, in this case, after the defence correctly filed the ex parte motion, somehow court staff erred in how it's processed into the system, causing Prosecutor McClelland to have access to the ex parte document. In her May 31st order, Judge Gull detailed how she sent the defence a tutorial paper explaining the process. The court implied that in said order that she sent the tutorial to the defence in order to assist the defence in learning the proper process of how to file an ex parte motion. Judge Gull's presumption that this tutorial assisted the defence is inaccurate for three reasons. One, the defence was not errantly filing ex parte documents. Two, the tutorial Judge Gull sent to the defence has nothing to do with assisting lawyers on how to file ex parte documents. So clearly she hasn't read it herself. she hasn't read the tutorial herself, or else she'd know that in the tutorial, it's actually for court staff, not for attorneys. Attorneys can't file things that court staff can file. And 3, the defence continued to file ex parte documents in the exact same manner it had been filing before Judge Gull ever sent the tutorial to the defence, and there's no issues. So they were doing their bit correctly. It's either the court staff that are doing it incorrectly, or they're doing it correctly and there's a leak. All right. Tutorial Judge Gull email to counsel is actually intended to assist court staff and clerks in how to properly handle ex parte documents after the private practitioner has filed the ex parte document. In other words, the document that Judge Gull refers to in her order does not in any way assist the practicing lawyer in filing ex parte documents, as it's a tutorial for court staff. So she's not read it, has she? She's not read it. Please find the attached printout of tutorial Judge Gull sent the defence marked as Exhibit B, which also includes the cheat sheet referenced in the letter from the Office of Court Services. Dear me. I've got this here. In her May 31st order, Judge Gull, referring to the email in which she provided the tutorial, states, another quote. She'll hate this. She'll hate this. She'll oh dear. She'll be fuming. Since that communication, defence have had no issues with their staff properly filing ex parte pleadings. This court attempted to give credit to the tutorial for her claim that no ex parte issues occurred after she sent the tutorial to the defence. However, this is simply not true, in that tutorial provided no guidance for practicing lawyers. As discussed above, the defence was already correctly filing ex parte documents. It seems likely that the actual reason for no further ex parte issues was that the court staff actually learnt the proper manner in which to process ex parte documents, or they stopped leaking them to Nikki. Even though on its face this tutorial clearly appears directed to assist court staff in understanding how to process and accept ex parte filings, the defence staff still reviewed the tutorial sent by Judge Gull to determine whether any part of the tutorial was meant to assist the practicing attorney in how to file an ex parte document. It does not. When defence staff clicked on the link detailed in step 1 and attempted to sign in, they were presented with a prompt that states, "You are not authorised to use this site." This is because, again, the tutorial that Judge Gull proclaimed in her order as helpful to the defence was actually meant for court staff. Yeah, I'm sure they do. Sure that they quote her emails just to wind her up. Yeah, they probably do. They work exactly as I work. Honestly, it's like proper passive aggressive, but very yeah, very in a very controlled way. Judge Gull has failed to admonish Prosecutor McClellan for improperly reading ex parte pleadings while continued to denigrate the defence counsel. Yes. Why has Nick not been held in contempt of court for reading ex parte filings? Why has he not been considered grossly negligent for reading ex parte filings? Why has he not been deemed incompetent for not understanding what ex parte means? All of those things are questions. I've got questions about all of these things. The pleadings errantly made accessible to Prosecutor McClellan were clearly marked ex parte. The defence became aware that Prosecutor McClellan read the ex parte documents based upon a March 6, 2024 prosecution filing in which the prosecution directly quoted from the defence's ex parte filing from February 26th. This document was clearly marked in capital letters at the top of the document, ex parte pleading to be placed under seal. And he shot himself in the foot by quoting from this one, but how many other ex parte motions had he read? He'd probably been reading them all, but he obviously forgot himself. Either that, or he doesn't understand the word ex parte. Sandra, member for 25 months. Best way to hear Delphi shenanigans. Oh, dear. After reading Prosecutor McClellan's March 6 filing and realising that McClellan had reviewed a defence ex parte document, Attorney Rosie sent an email to Judge Gull and one of Judge Gull's staff members, as well as to Nick McClelland. Find attached copy of said email marked Exhibit C. The email respectfully questioned how an ex parte motion was made accessible to the prosecution. Then, on March the 7th, Prosecutor McClelland filed a pleading in which he, McClelland, finally admitted he'd also had access to 3 other ex parte filings. After reviewing the record, the defence believes that Prosecutor McClelland actually reviewed only 2 ex parte filings, as 2 of the filings that he referenced in the pleading he identified as ex parte are not actually ex parte filings. So maybe Nick doesn't understand. Maybe he doesn't understand the term ex parte. Oh dear. Despite the clear marking of ex parte on the documents, Prosecutor McClelland chose to read those ex parte documents rather than promptly deleting them and alerting the defence to the misdirected filing. Yes, as required under Indiana Rule of Professional Conduct 4.4. So why is he not been deemed, grossly negligent? Why is he not being held in contempt of court? A lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender and, I would say, notify the court that something's going wrong here with the system. Prosecutor McClelland never contacted defence counsel after receiving the ex parte documents as required under Rule 4.4. The defence only learnt of this violation upon reviewing McClelland's March 6th pleading, in which McClelland audaciously quoted directly from the ex parte document, therefore making said quote available for public view. The act of McClelland reading from defence's ex parte documents provides the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. It is yet another example of a subversion of Richard Allen's due process rights. It totally is. This court has failed to reprimand the prosecution for reading ex parte documents or to even address that issue in any way whatsoever. Nor has Judge Gull filed a pleading in which she, Judge Gull, publicly proclaimed that she's referring Nick McClelland to the Office of Judiciary and Attorney Regulation Executive Director Adrian Meering for that office to enforce the rules or determine counsel's ethical misconduct. Woo-hoo! The court publicly declared in its April 30th, 2024 order that it was referring defence counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release that defence counsel sent out to media sources when no gag order was in place. This was going back to the beginning of December 2022. They sent a press release out on the 1st of December, and then quick, smart, the gag order was issued on the 2nd of December 2022. That's what they're referring to. And that was one of the things that she brought up when she tried to disqualify them. Okay. When there was no gag order in place, and after the prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on a much more serious allegation of McClelland reviewing ex parte documents and violating Rule 4.4, Judge Gull has said or done nothing. Judge Gull is clearly treating the prosecution differently than the defence counsel, and this provides a rational inference of bias. It absolutely does. And that's not an inference. That's obvious. That's not an implied bias. That's an actual, verifiable bias. That she admonishes the defence for things that they didn't even do wrong, and yet she refuses to do the same for the prosecutor, who provably has done something wrong. This court offered its hand-picked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for Rosie and Baldwin. Yeah, Yeah. She said to Scremin and Libretto that she chose, when they were the interim attorney, she said that if they were going to, follow the same defence strategy, that she'd let them have a hearing on Frank's one. And when Rosie and Baldwin took over, when they were rightfully reinstated by the Supreme Court of Indiana, she said no, denied without hearing. Yeah. So in her May 31st order denying the defence's request for disqualification, this court maintained that it had no bias against the defense counsel. On January 22nd, 2024, this court denied Baldwin and Rosie's request for a Franks hearing. At that point in time, this court had failed to rule on the Franks request for over 4 months. So the Franks one was published on September 18th, 2023. Yet, within 4 days of their re-entering their appearances on the case, Judge Gull denied their request without hearing. However, after Baldwin and Rosie were taken off the case in October 2023, Judge Gull informed her newly hand-picked public defenders that they should review prior counsel's pleadings and either adopt those pleadings or make their own. In that November 14th, 2023 entry, it was memorialized that Judge Gull informed the new public defenders, Scremin and Libretto, that if defendants' new counsel inform the court they intend to pursue the Franks motion, the court will schedule a hearing. She absolutely did. She absolutely did say that. Such action demonstrates that this court is punishing Richard Allen due to her bias against Baldwin and Rosie, in that after they re-entered their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion, which, while offering the replacement public defenders an opportunity to have a Franks hearing soon after their appearance on the case. I think she probably was going from the premise or the hope that Scremin and Libretto wouldn't deem the Odinist theory as a viable defence. I think that's probably what she was hoping, because she'd handpicked them. But then William Libretto went on record in the media talking about Odinism, saying it's scary. Did some videos about that back in the day. This disparate treatment of attorneys Baldwin and Rosie compared to this court's treatment of the prosecution and even of the replacement public defenders provides a rational inference of bias against defence counsel Baldwin and Rosie, and therefore against Richard Allen. Absolutely. This is great. This is a great piece of work. In its order, this court claimed that it's irrational and unreasonable for the defence to assert that as lawyers with 70 years of combined experience, they have never had a judge provide a hard end date for a trial. Calling defence counsel irrational and unreasonable shows bias, especially when the court is wrong in its understanding of Jury Rule 4. This court, unfortunately, continues to malign the defence counsel by calling them irrational and unreasonable for the averments? Never heard that word before. For their averments that courts around the state of Indiana never set a rigid day for trial to end. Implicitly, the court is also averring to that defence counsel are lying about their experiences in other courts around the state of Indiana. Furthermore, this court maligns defence counsel concerning its knowledge of the jury rules, when it is the court that is incorrect in its assessment of a juror. I've never seen a case that has a hard and fast end date. Surely they can't have a hard and fast end date. They can have a plan. They can have a plan of how long it's expected to run. Like in the Karen Reid trial, it'd be done and dusted if the court actually worked full time. We've got yet another day off today in Karen Reid. Then we've got a half day, and then we've got one full day, I think, on Friday. I mean, it's ridiculous. But they said that the trial would last maybe 6 weeks or 7 weeks or whatever it's expected. But now she's told the jury that they can expect to have the case the last week of June. But it wasn't hard and fast, because you can't have a hard and fast. You don't know what issues are going to arise, whether it's additional witnesses, how long witnesses are going to take. You can't give a hard and fast rule. Something practical might come up. I mean, the case I sat on as a juror in a murder case here in the UK back in 2020, they said that the judge said he expected the trial to run about 2 weeks, but it ended up running 3 weeks. But he said, at the beginning, he said, look, I expect it to run for 2 weeks. However, it's a murder case, and, if it's going to run longer, would that be a problem for you? Let me know if it's going to be a problem for you, because, obviously, if it's a problem, then they're not going to select you as a juror. They're going to select someone else. And it ended up running 3 weeks. So it was like 50% longer than he anticipated. And it was only one of the days where they actually couldn't have the court. Like, we all turned up and there was no running water or something in the entire building. So they couldn't flush the loos, couldn't wash your hands. So they had to send us all home. They couldn't run the court. There was only that one day when something like weird happened. But no, they don't have hard and fast end dates. It's ridiculous. Okay. At May 7th, 2024, pre-trial hearing, the court stated, well, you understand. Well, maybe you don't understand. Juror Rule 4 requires that I issue summons to the jury with the dates of the trial. Juror Rule 4 requires that I issue summons to jurors with the dates. Okay. The court cited Jury Rule 4 as a basis for limiting the time of the trial. However, Jury Rule 4 does not ever discuss the length or dates of the trial or require courts to place a hard end date for a trial. Jury Rule 4 states that not later than 7 days after the date of the drawing of names from a jury pool, the jury administrator shall mail each person whose name is drawn a jury qualification form and notice of the period during which any service may be performed. So the period, the whole period, it's not a hard and fast end date. It's saying, we expect this trial to last this long. However, it could last this long. Jury Rule 4 is primarily referencing to a time span or term during which citizens need to be on the alert that they could be summoned for the jury duty. While they are on call for possible jury duty, the prospective juror needs to be aware that over the course of a specified number of months, the court may summons them to appear in court as a potential juror. So it's not even saying this trial might last this long. It's saying you're under notice that you could become a juror for this time span. So for the next 6 months, you might be called on to be a juror. Slightly different way of working in the UK. The UK, you get a summons. You get a summons, and then you have to fill in some stuff online, like questions about like your mental health, whether you've done certain occupations and stuff. And presumably, if you say yes to any of those, you're automatically excluded. And then once you fill in your stuff and you get approved, then you send a letter, I think, or maybe an email, to tell you when to turn up at the court. And you turn up at the court, and they say that you basically turn up at the court every day for 2 weeks. So your jury duty is 2 weeks. But if you get put on a trial, then that might last way longer than 2 weeks. But you can tell the judge if you can only do 2 weeks. So there was one case, I wasn't on it because I was already on another trial. There was one case, it was like a drug deal, gang type case. And that was scheduled to last 6 weeks, possibly more. I was talking to one of the jurors who got selected for it. And she was going to be out for 6 weeks, if not longer. And look at Lucy Letby here in the UK. Look how long that lasted. No one could have predicted that Lucy Letby's trial could have, what did it last, like 9 months, something ridiculous? It was crazy the amount of time it took, that trial. And the jurors would have been told that it would be a lengthy trial, but they wouldn't be told exactly when that trial was due to end. Nobody could have predicted that that trial would have lasted 9 months. They'd have a good idea that it was going to be a long one. But no, you turn up and you get selected for certain trials, and then once your name comes out for a potential trial, then you're given like questionnaires and stuff from the attorneys, and then you fill those in, and then if the attorneys like confer, and then if you pass, then your name goes into a hat and then you get chosen. So it's a lot quicker. It's a quicker system because than what it appears to be in the US, because some of it's done online and most of it's computerized. It's only once you actually get selected for a potential trial. I think they took 30 names. And they gave us questions for this one trial, for the murder trial. They took 30 names, and then 30 people got to fill in the questionnaires, and then some people didn't pass the questionnaire. It was more to do with, did you know any of the witnesses? Did you live in this town? Did you associate with this bar? Did you do this? Did you do that? So some people got deselected because they knew some of the people, or they'd been to that town, or they'd been to that whatever, right? So it was much quicker. And took about half a day maybe from getting selected to that original 30 to actually sitting down and being sworn in. So difference, same but different. Same but different, I guess. All right. So jury rule 4 further states that when summoning as a prospective juror in for jury duty, that the summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communications devices, i.e. cell phones, PDAs, smartphones, etc., attire, meals, and how to obtain auxiliary aids and services required by the American Disabilities Act. Yeah, so that's very similar to ours. Okay, so note that jury rule 4 does not require the court to provide the dates of the actual trial or the length of the actual trial, nor does jury rule 4 require the prospective juror to be advised of the beginning or end date of the trial. Jury rule 9, terms of jury service, states a person who appears for service as a petit juror serves until the conclusion of the first trial in which the juror is sworn, regardless of the length of the trial or the manner in which the trial is deposed. So she lied. She either lied or she did not understand the jury rules in Indiana. Like, they could have gone to trial in May. The reason why it's been put off again is because she refused to allow the trial to run longer than the 31st of May that she'd allocated. That was the reason why the defense had to revoke, the speedy trial action, because she refused to extend the trial. So she said, well, if you want me to extend the trial date, then I'm going to have to, recontact jurors and we'll do it all again and blah, blah, blah. She's wrong. She's totally wrong. Dear me. Once summoned in and selected as a juror, jury rule 9 is the jury rule that comes to the closest to referring to a length of an actual trial. Note that jury rule 9 places no limit on the length of the actual trial once a juror is selected, nor does jury rule 9 place a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the first trial, regardless of the length of the trial, the authors of the jury rules innately understand that courts will not have a foresight to include an actual end date to a trial. As proof, in larger counties, jurors are summoned for a particular day and could be chosen to serve on any number of trials of varying lengths. In spite of Judge Gull's proclamation at the May 7th hearing, Indiana jury rules do not provide or require a mechanism to limit the length of the trial whatsoever, including as it relates to the information contained in the jury summons that the court sends to citizens pursuant of Jury Rule 4. Judge Gull's errant interpretation of Indiana jury rules creates a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure himself a trial where he could be thoroughly present, could thoroughly present his defense without time restrictions. Judge Gull's bungling of Mr. Allen's speedy trial right due to a misunderstanding of what the jury rules require in the summons only negatively affected the defendant and his constitutional rights, not the prosecution, and thus therefore provides a rational inference of bias against the defense and Mr. Allen. Terrible. In Marion County, for example, prospective jurors arrive and gather in a large room, not knowing which court or what trial they may be called upon. Yeah, that's the same as us. You all turn up. It's like an airport waiting lounge. You all wait up. You get some, like, in the first thing you turn up, you get played some videos of jury rules and blah, blah, blah. Yeah, all that at first. And then they start pulling names and what court you've got to go to. So it's possible to sit there in the airport waiting lounge for 2 weeks and not even get called. So that's very similar to this. Not knowing which court or what trial they may be called upon to serve, as often multiple jury trials are conducted at the same time and on the same day. The prospective juror could be asked to serve on any one of those trials. Yeah, it's exactly the same as ours. Susan, thank you for the $4.99. Thank you so much. I know you can't make this shit up, can you? You can't make it up. Can't make it up. Additionally, at the May the 7th hearing, Judge Gull cited several cases over which she presided that lasted less time than the defense is requesting on this case, essentially chastising the defense for the amount of time it was seeking for trial. The length of a trial is determined by the number of witnesses, the amount of evidence, and the length of the investigation, and the complexity of the issues involved. This is the case of State of Indiana versus Richard Allen, with its own set of facts, challenges, and potential pitfalls that could cause the trial to last beyond what the parties expect. For example, several witnesses reside 125 plus miles away. If those witnesses fail to appear in spite of being properly subpoenaed, the trial might be delayed while the parties try to determine how to deal with a witness whose car may have broken down or who may simply have ignored a valid subpoena. These situations arise in the trial, especially in a factually complex trial with approximately 185 witnesses identified by the parties. Additionally, of the approximately 185 witnesses identified by the parties, a dozen more are expert witnesses whose testimony will generally take longer and may be more complex than fact witnesses. For this court to call defense counsel irrational and unreasonable for stating the truth that they've never had a judge set a hard end date to a trial provides a rational inference of bias against the defense, or a complete lack of understanding of her own profession. Maybe. I mean, which is it? Additionally, it's shocking and disconcerting that the court refused to place a limit on the time allotted to the prosecution, but absolutely limited the time for the trial, thereby limiting Mr. Allen's time to present his defense. Yeah, so she had it scheduled for, was it May 16th or May 18th? And she'd allocated 3 days for jury selection, but the end date was the 31st of May. So Nick said, "Oh, I can present my case in 2 weeks." Well, how long did that then leave the defense to present their case? Zero. So if Nick said, "Oh, well, I can do mine in a week," and promised that he could do his in a week, he's not actually required to just spend a week. There's no law that makes him stop. So he could have dragged it out, And that would then have left the defence absolutely no time to present their case. That was the bind that they were in. That was the way that Nick was going to win. So the defence had no choice whatsoever. And she's trying everything. She's trying everything to scupper the defence. And that is constitutionally shocking, completely shocking, in my opinion. There's not mind, really, does the prosecution have evidence? Well, they have the bullet, the magic bullet. That's pretty much it. Because the bullet that, not a bullet, but an unfired round that had cycled through Richard Allen's Sig Sauer P226. That's the piece of quote-unquote evidence that they have that ties him to the crime scene. But there's contested science in relation to things like markings on fired rounds. There's contested science to it, but there's even more contested science to the markings on an unfired round that just happens to have been cycled through. But that's the evidence. There's no DNA, no fingerprints, no actual direct witnesses. There's somebody, a man, on the bridge that may or may not be Richard Allen at 2:13 that was taken by Libby German. Bridge guy, obviously. There's the sighting of the muddy and bloody man at 3:57. But Sheriff Liggett, or Detective Liggett at the time, lied and said that the witness had seen a muddy and bloody man. Actually, she'd only seen a man with mud on him, wearing a tan coat rather than a blue coat. It's contested and can't be proven what time Richard Allen was actually at the trails, because in his first interview, when he came forward as a witness, saying he was on the trails that day, Dan Dullard didn't bother recording that interview. And therefore, we don't actually know what time Richard Allen said he was at the trails, whether he, in October 2022, just before he was arrested, he said he'd left by 1:30. But we don't know whether that's a lie. We don't know whether he actually said what the PCA says he was there. We don't know whether that was another lie by Detective Liggett. So what evidence is there that Richard Allen was even there? Well, none. None. It comes down to the magic bullet. Comes down to the magic bullet. Was the unspent round found before or after they found his gun? Oh, but well before. It was found during the first few days, the inspection of the crime scene. However, the problem is, as well as the contested science, there's also a problem with chain of custody, because we're not clear who found that unspent round, and it appears that there isn't photographic evidence of there's no photographic evidence in the discovery of the chain of custody. So this bullet or this unspent round is photographed in the ground, and then it just suddenly appears in the lab. So they don't know. How do they know that they haven't changed, they've exchanged a bullet? So they found some. How do we know how old that unspent round was? How, that could have been there for years. So how do we know that unspent round is the same unspent round that they tested in October 2022 when they got his gun? You see what I'm saying? There's no thorough chain of custody evidence included in the discovery. So even the magic bullet is a problem. Yeah, the bullet could be from anywhere or anyone. Yeah, exactly. Without an adequate chain of custody, it could literally be any bullet from any gun at any point that was photographed in the ground. And then that could have been switched for an unspent round from Richard Allen's gun. Like they literally could have taken Richard Allen's gun and his ammo and cycled one of the rounds through the gun and then said that that was the one that they found in 2017. And there's no proof either way because there isn't an adequate chain of custody, at least that the defence has seen. And if they found DNA at the scene, it's not Richard Allen's. We don't actually know whether they've got DNA. It's been rumoured that they had DNA, but it's not Richard Allen's. So who's in it then? Whose is it? Salty Sleuth, Michelle, I've never seen this like this before. Have you? What, seen a case like this? The closest I'm coming to this kind of case is the Karen Reid trial. It's very similar in a lot of ways. That law enforcement have just been really, really poor at evidence collection, and there's more evidence for the defence's theory of what happened to John O'Keefe than the prosecution's theory of what happened to John O'Keefe. So it's very similar in the ways, very different evidence, very different trial, but law enforcement's inadequacies, just bad investigation and collusion is very similar to this. And the defence's theory is more compelling than the prosecution's theory. Exactly, Hardy. At least Karen Reid has a saying, Judge, yeah. Judge Bev, yeah. I mean, judges tend to be a little bit more critical of the defense than the prosecution, but she has been, generally speaking, very fair, generally speaking. But she's allowing the defense to present their case. Well, actually, the defense has not got to the presentation of their case, but she hasn't precluded them from cross-examining in any way. She sustains a lot of objections, but they're still able to deal with it. And she'll kind of help them out. She'll go, you're nearly there. Ask the question in a different way. You're nearly there. She kind of helps them. There's rumours about animal DNA too. Richard Allen's cat, a horse, who knows? Yeah, there is rumours of, well, there was hairs. Let's put it this way. In the search warrant for Ron Logan, which was leaked, it was stated that there was hairs found at the scene. It was also then rumoured when Richard Allen was arrested that they dug up the yard to exhume Richard Allen's dead cat. Now, we've never had actual confirmation that they did that. It came from a neighbour in the October 2022 when he was arrested. But we do know that Richard Allen had a dog. And we do know that there was hairs found at the scene. But clearly they didn't match, because if there was hairs from an animal in Richard Allen's home, that would have been evidence that they could have presented, good evidence, very strong evidence of his. I mean, how would hairs from Richard Allen's dog or cat, how would they get on the bodies of Abby or Libby? Unless Abby and Libby knew Richard Allen, had been to Richard Allen's house and had been petting his dog, how would hairs from Richard Allen's house of any kind be at the crime scene? So they clearly haven't made a match between the hairs at the crime scene which we know there was some hairs, and anyone from Richard Allen's house, human or non-human. So again, we've got these unidentified hairs that came from somewhere. Now, they could be from anywhere. You know, Abby and Libby could have been petting a dog or a cat, you know, the same day that they were murdered, or it could be hairs that were, you know, the clothes have been washed and hairs cling. Right? You can wash your clothes and the hairs are still clinging on. When you've got a cat that's molting, the hairs cling on. They survive a washing cycle. So yeah, there's no matches at all for Richard Allen at the crime scene. None. Nothing. So where were those hairs from? Were those hairs indicative of anything? They could be hairs that fell on the victim after they were dead, like when they were led there for like 24 hours. Like there's loads of deer in those woods, squirrels, rats. It could be hair from any number of wild animals. So there's no evidence that the hairs are relevant even, but we do know there were hairs at the crime scene that didn't belong to Abby and Libby. But equally, evidently didn't belong to Richard Allen or any human or non-human that was living in Richard Allen's house that could be, you know, transferred from his clothes. All right, but good question. We don't know that. We'll find out until the actual trial. Yeah, we would know that. That would be something that they would have put in the PCA. I'm sure of it. Please don't tell me off, but I've been watching Gray Hughes videos and he claims he can match Richard Allen's phone movement to the girls. How does he know Richard Allen's phone movements? How does he know that? Because we haven't had any things like phone ping data has never been released. So how can anybody match Richard Allen's phone? So either phone pings or GPS from his phone. How can anybody match that to Richard Allen when none of that information has been released? So how? I mean, point me to that information if I've missed it. Point me to the phone ping data that's been released. I mean, this is approximately what it might look like. Hold on a minute. Just let me get the Stefan Stearns discovery up for a second. Just 1 minute. Just let me load it in. All right. Takes it a minute to load because it's like 900 pages. All right. So go right down to the bottom. Right. This is what phone ping data might look like. So this is what you're looking for in the documents. Come on, you can do it. It doesn't want to load 900 pages. Come on, you can do it. It's struggling. It's really struggling. There we go. It's coming. Come on, you can do it. Here we go. It's coming. All right. This is what it looks like. This is phone ping data. So in a future episode of the Stearns Files, when we get to it, we're going to be looking at all this phone ping data. So this is what it looks like. So you can track the movements of Stefan Stearns by his phone ping data. Oh, all the way along that road. Those are the different phone pings. On 2:25 and then specific times. So if there's documentation in relation to the Delphi case, that has data that looks like this, that I've missed, let me know. It'll look similar to this. So that's your task. Where's the phone ping data? There's pages and pages and pages of this. Tracking his car, tracking Jen's phone. The car here that's depicted is where it's been caught on cameras. It's very, very interesting. Lots and lots of pages of this. We're going to be going through all of this in the Stearns files when we get to it. We've got a while though before we get to it. This is in the, it's like loads of it. Like it's literally probably half of this discovery is to do with tracking via phone, via surveillance cameras. I mean, literally, it's half of the discovery. That's why the discovery is so long. So don't worry, we'll get there. We'll get there. So keep watching the Stearns files. I can't tell you what episode it's going to be. I'm just carrying on with these daily Stearns files episodes until we get to the end. But there's going to be maybe probably 2 episodes going through all of this surveillance data. All right, so I've got to get the Delphi one back up now. Just find it. Here we go. All right. Well, does anybody know what page we were on? I think we're like page 14, maybe. Okay. Oh, yeah. Yeah. Where are you? Okay. We'll start here. All right. Okay. Page 14. For this court to call defence counsel irrational and unreasonable for stating the truth that they have never had a judge set a hard end date to a trial provides a rational inference of bias against the defence. Additionally, it's shocking. Oh, I've read that. Disconcerting. Yeah, read that. The hard limit on the end of the trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process of a witness, and his 14th Amendment right, due process right to present a defence. In the context of its request for Judge Gull to disqualify herself, this court's maligning of defence counsel as irrational and unreasonable, when in fact it's this court that is wrong in its understanding of jury rules, and also wrong in its claim that courts statewide provide a hard end date to a trial, offers a rational inference of bias against the defence. Judge Gull's May 31st, 2024 explanation of her denial of defence motions without a hearing provides a rational inference of bias. In its May 31st order, when explaining why the court denied several defence motions without hearing, the court stated, if pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. This court knows very little about this case, especially compared to the lawyers litigating the matter. Therefore, how could this court determine what evidence would be admissible or inadmissible until a hearing takes place and the defence moves to admit the evidence, subject to possible objection by the prosecution? Exactly. You know what? How many hearings have we actually had in this case? Very few, compared to other comparable cases. You know, I like pre-trial hearings. I like watching pre-trial hearings. But in the Karen Reid case, they had loads of pre-trial hearings, loads of them. Really interesting. You know, because you get to learn what you're going to hear at trial and what's not going to be allowed. But there's been very few in this case. So how does the judge know? Because especially as we know that she doesn't read filings. She clearly doesn't read filings. And she's denied the Franks motion, denied that without hearing. So that would be, the Franks hearing, she'd get to know all the evidence that they've actually got. That's, a different theory to the one that the prosecution are bringing against Richard Allen. So how does she know to deny something when she hasn't actually heard the evidence? I think there's some information on phone pings, but there were several phones, and I don't believe we know who they belong to. Is that correct? Yes, that is correct. What we don't have is the data. So the data from specific phones, and we don't have the geofencing data. That's never been released. So how do we know what phone to track? How can we track a phone when the data hasn't been released? Okay. So Judge Gull's claim that defence evidence is inadmissible before conducting a hearing and before listening to the defence's contextualisation of the evidence surrounding their legal argument provides a rational inference of bias against the defence. Yeah, she can't be asked. She can't be bothered. This court's denial of defence motions without a hearing, based upon reason this court cites in its May 31st order, establishes that this court is prejudicing the defence evidence as inadmissible. Also, this court claiming that the law does not support the defence pleadings before this court, even hears any evidence, is additional proof that this court is prejudicing evidence. This court's denying the defence's requests contained in its pleadings without a hearing, based upon her prejudicing evidence, provides a rational inference of bias. In the future, if this court denies defence motions based upon the court's belief that the defence pleadings not supported by law are admissible evidence, the defence then requests this court to identify the evidence cited in the defence's pleadings that this court believes is inadmissible, and then to explain why the court believes the evidence is admissible also, instead of simply stating denied without hearing. The defence will request the court to explain why the pleadings is not supported by law. She won't. She won't. She'll deny that without a hearing at all. Even concerning something as basic as a request for a recess, Judge it's insane. Judge Gull shows favouritism to the prosecution. In her May 31st order, Judge Gull expressed that she does not show favouritism to the prosecution. However, Judge Gull has shown her differential treatment between the prosecution and defence in a variety of ways. Some are easily identified, some are less perceptible. For example, because cameras have not been allowed in the courtroom, it's difficult to hear Judge Gull's angry tone when addressing the defence versus how she speaks to the prosecution, and also to visualise the court's disdainful facial expressions she makes towards the defence versus the prosecution. Yeah, you can request a transcript. You can get a transcript of any hearing. You know, some creators like Criminality's been getting transcripts and you know, doing read-throughs and stuff, which is really interesting. So you hear the words, but exactly, you don't know the tone, you don't know her expressions, you don't get the context, do you? Like the, you know, the non-verbal, like, you know, context. But if she was doing that through the trial, that in itself would prejudice the jury. If she was doing that, like being very short and curt and rolling her eyes and doing whatever facial expressions that she's doing against the defence throughout the trial, that would be perceptible by the jury. And that would be prejudicial. Although it may seem petty or trivial to the court, the defence offers an example of her disparate treatment concerning something as mundane as how the court handled a simple request for a recess during a hearing. At June 15th, 2023 hearing, Prosecutor McClellan requested a recess and the following transpired. McClellan: Judge, I have 2 witnesses. Could I ask the court for a short recess so that I can just use the restroom? Judge Gull: would counsel approach? Sidebar. Judge Gull: I just want to know kind of where we're at. You've got 2 witnesses. McClellan: Tony Liggett and the Westville warden. Judge Gull: okay. Do you want to break for lunch? Rosie: I don't, but I'm. Judge Gull: okay. So I don't care. I can. Yeah, we could take a quick break. How long? I don't mean to be a pain, but I'm desperate for a wee. Please let me go. No, that's all right. How long do you think you'll be? Downstairs and right back up. No, I mean in your witnesses with your evidence. Oh, ding dong. What? Ding dong? She says ding dong. Judge Gull, ding dong. I don't care how long it takes you to go there. No, I don't care about that. Ding dong. What's ding dong? McLeod, I don't really think too long, Tony, about the transportation resources, and then Gallipo just to address allegations they've made in their safekeeping. So like another hour, an hour and a half, I guess. I just couldn't. So he can't say how long it's going to take to interview two witnesses. He doesn't know how long it's going to take. So there, exactly. Try a trial. You don't know. You might give a rough estimate that, oh, I've got maybe half an hour's worth of questioning or 40 minutes worth of questioning. But you don't know because you don't know how many additional questions you're going to have to ask. You don't know how long the witnesses' answers are going to be. She's calling him a ding dong. She's just a weirdo. Let's just break for lunch. I know you don't want to, but too bad. Rosie, I'm fine with whatever. Okay, let's just break for lunch. Rosie, I don't have anywhere else I need to be. Well, I know you don't, because you were supposed to be here for 2 days. However, at the May 7th, 2024 hearing, the court treated the defence much differently when the defence sought a short recess to confer with their client on urgent matters concerning the positive negatives of continuing Mr. Allen's speedy trial due to Judge Gull's hard end date of May 31st. Following a back-and-forth exchange between Judge Gull and defence counsel concerning the defence needing more time for trial, Judge Gull was allowing this occurred. Rosie, can we have 5 minutes? Why? I would like to speak with my co-counsel here and have a discussion about the business issues, such as scheduling, not here in the courtroom where everybody's listening to us. We've got, 50 staff members in this courtroom, people sitting behind, there's no privacy, and I'd like to talk to him in the hallway about some of the logistics of this so we can solve the problem so that he, Mr. Allen, can put up a defence. Judge, does the state of Indiana have any objection to a recess? No, Your Honour. All right, Jodie, you can go off the record. Judge Gull did not playfully call Brad Rosie ding dong, but instead questioned Rosie's reasons for seeking a recess. Then Judge Gull surprisingly asked the prosecutor if he had an objection to seeking a 5-minute recess so that the defence counsel could talk to their client about the important matters concerning seeking a continuance of a speedy trial due to the trial court's unwillingness to provide more time for the defence at trial. When a defence attorney requests a 5-minute recess to talk to their client on such weighty matters as their constitutional rights related to continuing a speedy trial, it should be met with simply, of course, and should not require approval from the prosecutor. Exactly. The fact that Judge Gull treats the defence differently on such a basic matter as request for a recess provides a rational inference of bias. It just is. It just is. She has to be losing her marbles. Yeah, ding dong. You ding dong. You're ding dong. This court failed to address the appearance of bias which exists in this case. Judge Gull claims in her order, as counsel should know, criminal cases are tried in a court of law, not in the court of public opinion. However, the standard for recusal is not just whether actual bias exists, which it does, but also whether the appearance of bias exists. The judge must consider both actual bias and the appearance of bias when determining whether to disqualify herself. Judge Gull appears to conflate the general concept in this occasion. The public will vehemently criticise the judge with the defence, the specific contention that many in the public are particularly criticising her for what the public perceives as actual bias against the defence. The emails which the defence attached to the motion and the memes the defence referenced in the motion detail how the public believes that Judge Gull is biased against the defence. The defence agrees with this court that general complaints by the public concerning the court's rulings should not cause her to disqualify herself. although the defense believes actual bias exists, it's the appearance of bias against the defense about which the public has complained. It's this appearance of bias against the defense about which the public has written the Indiana Supreme Court. It's the appearance of bias against the defense about which the public has written Judge Gull. And it's the appearance of bias against the defense, the existence of which Judge Gull should recognize and for which Judge Gull should voluntarily recuse herself. So more appearance of bias and impartiality may require recusal if an objective person knowledgeable of all the circumstances would have a rational basis for doubting the judge's impartiality. Part of the legal reasoning contained in her order, Judge Gull cites to being threatened with bodily harm and injury. She's not alone, as defense counsel have also received death threats and threats of bodily harm. Regardless, the defense sees no linkage between whether an appearance of bias exists and Judge Gull's mentioning that she or any party has been threatened. It's true that many of the public have written both Judge Gull and the Indiana Supreme Court to complain that the judge is wrong in various rulings, particularly whether the judge should allow cameras in the courtroom. However, these complaints would not support the appearance of bias. Yeah, those are just opinions, aren't they? But it's the difference in the way she treats the defense to the way she treats the prosecution. The way she's treated Brad Rosie and Andrew Baldwin, and by extension, and sometimes directly, Richard Allen, shows she's biased. She absolutely is. There's nobody, surely, who would, if you were objective, you wouldn't see that. Failure to address other issues contained in the first motion to disqualify. This court addressed a few other defence issues contained in their second motion to have Judge Gull disqualify herself. The defence stands by those reasons as well and does not waive those issues for purposes of appeal. See, this is all gearing up for the appellate courts. However, in its May 31st order, this court failed to address all issues contained in the defence first motion to have Judge Gull disqualified, which the defence incorporated into its second motion. The defence requests Judge Gull to review the first and second motions to disqualify and consider whether she feels obligated to disqualify herself from this case based on the itemised reasons contained in those motions, as well as in this response. Conclusion. The defence wishes to move forward and have this court conduct hearings most immediately and request to have Richard Allen removed from the Department of Corrections to either Cass or Tippecanoe County jails while waiting trial. This motion is intended to respond to Judge Gull's order for purposes of preserving the issues for the record and so that Judge Gull may consider whether or not she feels obligated on her own to recuse herself from this case, which remains an ongoing obligation whether or not the defence is seeking her recusal. I can see this going back to the Supreme Court at some point. Wherefore, the defence files its response to Judge Gull's order, blah, blah, blah. Respectfully submitted, certificate of service. Honestly, seriously, wow. That's a good one. That is a good one. I'm loving it. Sometimes wondering whether she's trying to get herself kicked off the case. Because if she recused herself, maybe her life will be in danger. Wow. Don't know. No one sees these memes. No, I don't think the memes have been released. The letters that have been sent to her, she puts them on the record. But I don't know about the memes. I don't know about that. So many appellant issues there is. There absolutely is. So many. If he gets convicted, Richard Allen gets convicted in October, this case is going to go through the appellate court for years to come, potentially. And that is not justice. It's not justice for Abby and Libby. It's not justice for the families. It's dragging it out for more and more and more years. Richard Allen has to have a fair trial, whether factually he's guilty or factually is innocent. He has got to have a fair trial, so that whatever happens, whatever the jury decides, is done in a way that cannot be contested. And the way that Judge Gull has operated, it's signed the defense. And those who believe that Richard Allen's guilty should be jumping up and down from the rooftops to say, look, we do need a different judge because of this appearance of bias. We need a different judge to ensure that the jury, the public, the good people of Indiana are confident with Richard Allen's conviction if and when it comes. It shouldn't matter whether you believe Richard Allen is guilty or innocent, like factually. It shouldn't matter at this point. What you should all realise is that for justice and a fair trial for Richard Allen and justice for Abby and Libby and their families, this has to be done in a way that allows the defence adequate, satisfactory, just allows them to present their case, so that if he is convicted, it's fair and square, and that jury has decided that he's guilty based on the evidence, and it's beyond a reasonable doubt. I mean, how would you feel if, Richard Allen was acquitted because the prosecution's case wasn't strong enough and the jury perceived that, the judge was biased? How would you feel if he was acquitted? So, those of you who believe that Richard Allen's guilty, if he's acquitted, he's acquitted. That's that. But what if, when the jury, he's allowed to, after the trial, he's allowed to come out and speak and says, well, we could clearly see that the judge was biased. And, the evidence against Richard Allen wasn't that strong. And it was clear that Richard Allen really wasn't granted adequate constitutional rights. And therefore, we had lots of reasonable doubt. And therefore, we had to acquit him. How would you feel? How would you feel? So I'll leave that one with you. Leave that one for you to ponder. The judge needs to recuse herself. She absolutely does. Doesn't mean that the entire case is going to be, in the pre-trial stage for years and years to come. A new judge should be able to just step in and get up to speed pretty quickly. Grant the hearings that need to be had and basically, learn the case from, as much as the judge needs to learn the case at this stage. The judge recuses herself. There could be, all things considered, the trial could go ahead in October. There's plenty of time. 4 months yet. So, yeah. Recuse yourself, Judge Gull. Appoint a new judge and we'd be good to go, in my opinion. This is the point. This is exactly the point that I'm making. He might get acquitted, which does not mean he's not guilty. Exactly. So for those who believe he's guilty, how would you feel if he got acquitted? If the jury perceived not only the case to be weak against him, but that the judge was biased? How would you feel? How would you feel? Those are the things you've got to consider. So if you believe Richard Allen is guilty, you have to agree, surely, with me that the judge should recuse herself. I will leave that one with you because I'm going to go now. So I shall be back in 4 hours. I'll put the scheduler up in a little while. for the Stearns files. So we're starting at page 104, I think. Where are we at? 104. So this is the Stearns files. So we're starting with the interview with hold on, where are we at? So we've got that page to read about surveillance, and then we're into the interview with Maddie's friend, and then we're going to see how far we get later on. 4 hours time. I'll put the schedule up in a bit. So thank you all for joining me. Hopefully you can join me later on for the Stearns Files episode 4. And yeah, so thank you all. Thank you, mods. Thank you for the donations. Welcome to the new members. And I will see you in 4 hours. Bye, guys.